Critical Documents, prepared for and presented at the 2016 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
What I plan to do today is approach critical documents from a cradle to grave perspective. Think about formation to exit and kind of give you a guided tour of some of the critical documents that you'll see while you go through that process. The 4 phases that we're going to talk about today, wrong button. There we go. It's not my MacBook Air, so I'm confused. All right, here we go. Oh, nope, let's try one more time. Playing transition. Nope, go back. All right, oh, here we go. All right, so we're gonna look at, there we go. The 4 phases of the business life cycle. We're gonna talk about entity formation. Just on a high level, Angie did a killer job of giving you guys a big picture about that. We're going to talk about raising money and or obtaining financing in a more traditional sense. We're going to talk about general contracting, again, those bread and butter type contracts. And then we're going to talk about exit. So what does an exit look like? And we're going to have a few detours along the way. I mean, that's just how a guided tour works. I'd like to do questions a little differently today. So I'm going to go through each of those 4 phases, and when we get to the end of the phase, I'm going to ask for questions. That way you guys don't feel like you have to interrupt in the middle, and you don't have to save everything until the end. So sound like a good plan? Awesome. Okay, so let me start by asking you a few questions. Who in the audience has formed a company before? Oh, got a bunch of sophisticated folks in there. Keep your hands up. Of those who have formed a company, keep your hand up if you have raised capital before in your company. All right, got a few. That's excellent. Okay, and then who has contracted through the company that they've formed? Keep your hand up if that's accurate. Excellent. Or if you haven't raised money, you can put your hand back up. There you go. Okay, and then who has formed a company that has exited at some point? Who's had a successful exit? All right, congratulations, folks. It's a hard road. Okay, that's helpful because knowing your audience and understanding, what you've seen before helps inform me and how I can best talk to you about what we're gonna go through today. So, all right, there we go. Formation of a company. So phase 1, formation. Again, like I said, Angie did a phenomenal job. So I'm just gonna talk really high level. These are the critical documents that are involved in the formation of an LLC. As Angie mentioned, your articles of organization are filed with the Secretary of State in which you're creating the company. The operating agreement is kind of like the playbook, the rules of play or the playbook, right? Operating agreements with LLCs have 2 parts. They have the rules for how you run the LLC, and they have the rules by which the members interact, right? A little different than with a corporation, which we'll get to in a minute. And then you have an EIN or an employer identification number. I always think of that as like the social security number for the company, if that helps you. And then just to kind of add to what Angie said, there are a couple reasons as to why you would want to form an LLC over a corporation that are somewhat unique. The first is that with an LLC, and I'll give the caveat, also not an accountant, but I know enough to speak the language. So with an LLC, if you're a startup, in the beginning you're not making a lot of money, or maybe you're not making any money. You're just paying out money, so you have losses, right? If you have an LLC, the LLC framework allows you to take those losses personally. So if you're in a situation where you're not making money with an LLC, you can at least take those losses and offset them and carry them forward. Also, with an LLC, there's this concept called profits interest, and Angie touched on it briefly. Profits interests are a form of a non-qualified employee benefit. That means they're outside of the really complicated IRS rules and balance testing and all of those crazy things that go into qualified employee benefits. The way profits interests work is that you have an operating agreement that allows you to utilize profits interests. You have an incentive unit plan, and you have an award agreement. So those are your critical documents. When you have an award agreement with your employee, independent contractor, or service provider that you want to compensate with profits interests, in the award agreement, you set what's called a distribution threshold. That's essentially the value of the company on the date that you grant the profits interest. What's great about profits interests is that on the date that they're granted, they have zero value, right? The reason that they have zero value is that nothing is distributed to the profits interest holder until the net cash flow of the company exceeds that distribution threshold, right? So for the employee, it's not a taxable event, which is great. It also incentivizes the employee to grow the company to a greater value than it currently is today, because nothing is distributed to that employee, and I keep using employee, but it could be independent contractor or service provider, until the value of the company gets above that. So really great tool to use, and only LLCs allow you to use them. There's also this thing called phantom equity, which is very similar to a profit, not very, somewhat similar to a profits interest. Phantom equity is exactly what it sounds like. It's not real equity. So profits interest is actually real equity in the company. Phantom equity is just shadow equity that typically an employee or independent contractor loses when they leave the company. So just a couple things on LLCs in addition to what Angie talked about. Next, we're going to talk about the formation of a corporation. And Angie touched on this. You have bylaws, you have certain consents, you have shareholders agreements, and you have an EIN. Big picture, contrasting to an LLC. I said an operating agreement sets forth the rules of the company and also how the members interact all in one agreement. With a corporation, you have the bylaws, which are more like the rules of the company. And then the shareholders agreement, which if you have multiple shareholders in the corporation, set forth how the shareholders interact and contain things like buy-sell provisions, similar to what Angie talked about. Again, just two quick things on corporations. The first is that, I think Angie very clearly did a great job in talking about how an LLC is the most favored and most flexible entity, right? But when you are looking at a corporation, the reasons why we see companies choose corporations are that they are on a trajectory which is clearly going to include raising capital from a VC fund that prefers to invest in corporations. It's almost impossible to know without looking at just past history of investing what the VC fund is going to invest in. In fact, we had a company come to us not long ago and said, look, I want to put together investors from the coast to invest in my company. What type of entity do California investors typically want to invest in? We have a contact out in California that's very similar to our firm. We got her on the phone with him. And the upshot was that it's both. It's a mixed bag. Investors very regularly invest in LLCs. Certain VC funds for tax purposes want to invest in a corporation. So you got to do your due diligence to figure that out. Another really interesting one is that there is a section of the Internal Revenue Code. It's section 1202 that pertains to qualified small business stock. Qualified small business stock, if held for more than 5 years and there are certain other conditions that are met, allows the investor to exclude essentially all of the gains from the sale of that stock from their income tax, which is huge, from their tax returns. So certain savvy investors are get really excited when they hear that a company has chosen a C Corp because they plan to follow this trajectory. It's a huge enticement to investors to potentially invest in your company, but really only applies to very sophisticated investors. Then just one more quick thing. It's really easy for an LLC to convert into a C Corp. There are incredible tax consequences when you go backwards. So when folks come into our office and they say, hey, there's one or two of us, we want to form a company, we don't really know where we're going to go from here, our recommendation is almost always LLC, because you can change. You can convert to a corporation. Okay, so that's it for formation for me today. Does anybody have any questions? 1202. Yeah.
How do you define consents?
So Angie talked about incorporator consents and shareholder consents. There are just a list of, oh, you mean what exactly is a consent?
Yeah.
Sure. So you can either hold a meeting of your shareholders to vote on a specific issue, and the dates and times and numbers of days of notice are all set forth in your bylaws or shareholders agreement, or you can do a written consent. And that written consent essentially puts in writing everything that you would decide at a meeting of the shareholders. Everybody signs off on it and they all agree. Does that make sense?
I think so.
Awesome.
I have a question. Can you set up a holding company? Is the holding company set up as an LLC, and then underneath it you will have other LLCs or C corporations?
The iterations are limitless. They really are. There's not a lot of situations where a holding company makes sense in an early stage emerging company situation. But I mean, the iterations of how you can set up and structure the corporations or LLCs it's limitless. It really is. Awesome. Okay, well, let's keep going then. We're going to take a quick detour and talk about confidentiality agreements. They don't really belong in any phase. I'm certain I'm going to trip over this at some point in time. They don't really belong in any phase. Angie touched on them briefly. Brian's going to talk a little bit more about them. Here's what I want to tell you about confidentiality agreements. They are almost always my recommended first step in a contracting process. Okay, we'll talk a little bit more about what that means as we go through. The important things, the important points in a confidentiality agreement are: number one, the definition of confidential information. There's a pretty generic definition that appears in almost all confidentiality agreements. We also call them NDAs, or non-disclosure agreements, so you'll hear those phrases used interchangeably. But if you have a specific trade secret or set of trade secrets, or if your customer list is really important to your business model and it's important that you protect that, make sure those things get into the definition of confidential information. And then where confidentiality agreements are really powerful is in limiting the use of the confidential information. So essentially what this says is, I'm going to give you, the receiving party, my confidential information. And you need to protect it as if it were your own, and you can't disclose it. But in addition to that, you can only use it for certain things. So we put together a number of flavors of confidentiality agreements. One is for an investor, and the use is limited to investment considerations. One is for an employee, and the use there is limited to performing the job. One is for an independent contractor, where the use is for performing the task or tasks assigned. Another is for general contracting, where the use is limited to providing services. And then finally, in an exit, so in your M&A transaction, when you exit, the use is for evaluating the potential transaction. So those are the key takeaways from my perspective for a confidentiality agreement. And like I said, I know Brian's going to talk a little bit more about it. I got a peek into his presentation. Okay, so next let's talk about phase 2, which is raising money. And in phase 2, we're going to talk about a couple things. We're going to talk about capital raises, and we're going to talk about traditional loans. But I would be remiss if I didn't mention bootstrapping, which is the old-fashioned way of starting a company, right? You put your own equity into the company until it becomes profitable. So generally, when it comes to a capital raise, startups look to their attorney to provide some guidance on how they're going to structure the raise. Should it be a convertible note? Should it be an equity round? Once you have an idea of how you're going to structure the raise, what's the term sheet going to look like? What provisions should go into the term sheet? How do you draft a term sheet? Who negotiates the term sheet? Who comes up with it first, the company or the investor? What are the subscription documents going to look like, or what is the subscription package composed of? What disclosures are required? And then on the back end, cap table management, which we won't talk a lot about today, but it's still very important. This is the part where I talk about how important your accountant is. We don't do a single capital raise without involving the company's accountant. And here's why. When you're evaluating what your raise should be, how it should look, how much money it should be, what the qualities are, your accountant can help you put a model together to figure out number one, what's the value of your company right now? So if it's $1 million and you're looking to raise 1.5, well, you've got a problem, right? And how do you address that problem? They can also help you again on the back end. I mentioned cap table management. So we have a lot of clients that have gone out, they've raised, let's just say $500,000. Their round is closed, but they're also still incentivizing their employees, independent contractors, and service providers with profits interests. Each level of which has a different distribution threshold. And when you put all of that together, it becomes very complicated to keep track of. A good accountant who's very familiar in this space can really jump in and help you with that. And I highly recommend that you find one and get one involved right away. Okay, so who has heard that investors don't sign non-disclosure agreements? And who believes that? Okay, I'm here to prove you wrong. Hold on, are you an investor?
Yeah, I work with a venture fund, and ours does.
Yeah.
Because we're a seed stage fund and special purpose. Many will not for early stage meetings.
Sure.
Will maybe if you get to the term sheet stage.
Absolutely. No, that's a great perspective. Thank you. And that follows along with how we advise our clients. We talked a little bit about a flavor of confidentiality agreement that's for an investor that restricts the investor from using the confidential information for the investment consideration. So that's the flavor of confidentiality agreement that you would use here. And from a process perspective, our position is have those high-level discussions with your investors about generally what your company is and what it does and how you do it and where you see the future going. But when you get down and start talking nitty-gritty trade secrets, things like that that are incredibly critical and important to your business, always offer up a non-disclosure agreement. Always ask. The worst that they can say is no. And we see investors signing non-disclosure agreements, I mean, more than half the time. I'd say probably even more than 60% of the time. Especially if you're looking to just raise from 1 or 2 angel investors. We see that pretty regularly as well.
I should clarify, all my comments related to professional investors, not angels.
Fair. Okay. Perfect. 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 All right, so let's talk a little bit about the framework for subscription documents, and this is 2 slides. So we're going to start generally with the term sheet. And the term sheet is going to state what the type of raise is, right? Typically, early stage companies, we see a convertible note or some sort of common equity round. Occasionally, we see a preferred round. All of those tools can be used to sell units in an LLC or stock in a corporation. So know that from a big picture framework perspective. A convertible note is a loan, but it's also equity. It's one of those crazy hybrid tools. And essentially how it works is that an investor loans, putting that in quotes because it's still equity, loans the company money at a certain interest rate for a certain amount of time. And the trade-off is that if the company raises more than X amount of money, the investor can convert its loan into equity at a discount. So that's kind of the basic framework and how a convertible note works. Equity is what it is. You're selling it for a price based on a valuation. There can be preferred characteristics with that equity. Oftentimes it's a preferred rate of return or a preferred method you get paid first, so a preferred waterfall of payments. But those are kind of the typical high level. All of that goes into the term sheet, along with some typical disclaimers, shareholder rights, what have you. Term sheets differ from company to company, from investor to investor. The question of how you negotiate those or how you put together a term sheet always comes up. I advise my clients to put together the term sheet themselves based on the raise that they're looking for, and then start socializing it to potential investors. Gauge the return. If people laugh and walk away and say, wouldn't touch that with a 10-foot pole, well, you're on the wrong track, right? So you go back to the drawing board, sit down with your advisors, and try to figure out how to go back. Okay, so quick detour here. Again, I don't have the plague, but still going on here. Quick detour here. Let's talk about why securities law documents are important. And no one tells startup companies and founders this, so I'm going to tell you something really important. Pay attention. Because your lawyer is going to tell you when you're going to raise capital that you have to put together all of these documents, and it's going to sound like a lot of work and a lot of legal fees for no reason. Here's why. The Securities Act requires that the issuance of every single security be registered with the Securities and Exchange Commission. That is an incredibly expensive, time-consuming, and frustrating process, and no one wants to do it. So luckily for all of us, there are some exceptions to that requirement, the registration requirement. But along with those exceptions come certain requirements, right, in order to qualify for those exceptions. The biggest one, the one that's most important to you, is the requirement of material disclosure. If you don't disclose to investors anything that could be material to their investment, right? If there's litigation, you've got to tell your investors about the litigation. Somebody once told me a good rule of thumb is if you don't want to tell people about it, tell your potential investors about it. Here's what happens. If you withhold something that's material from your potential investor or from your investor and they invest in the company and the company goes belly up and they lose all of their money, they can sue you personally and the company both civilly and criminally. You personally and criminally and the company civilly and criminally. So Angie and I talked a little bit about how limited liability protection creates this barrier, right? So long as you follow the appropriate corporate governance procedures, creates this barrier between your personal assets and the rest of the world. If you don't abide by the securities law registration requirements or exemptions there too, the court will pierce that veil and there's personal liability for you. So that's why what we're talking about today is really important. Okay, so what does the subscription package look like? So here's how we approach it from our perspective at KWS, and we mirror a process that's used by a firm out in California that's just like us. Big firm lawyers started their own shop. They do capital raises for Silicon Valley on a daily basis. If you have a small raise to a small number of investors and they're all accredited investors, we don't go through the private placement memorandum process. We do an umbrella subscription package, okay? So what's the difference between the two? I will, absolutely. No worries. Okay, so what's the difference between an umbrella subscription package and a private placement memorandum? Private placement memorandums are expensive and time-consuming. Here's what happens. Your lawyer says, I need all of this information about the company. It includes things like your business plan, your projections, your sources and uses, which we'll talk more about in just a minute. You send them to your lawyer. Your lawyer does additional due diligence into the company. We read, we digest, we internalize all of that information, and then we regurgitate it into a private placement memorandum, right? But in order for us to analyze and read and understand, it becomes a very time-consuming process. With your subscription package that we do, again, small raise, small number of investors, accredited investors only, which to Christy's point we'll talk about, we do an umbrella subscription document. And that umbrella subscription document has instructions for completion, where to send the funds, who to contact for more information, the actual subscription agreement itself, which is the purchase agreement for purchasing whatever type of security you're selling, be it a convertible note, be it equity. And then we have certain exhibits. If you're selling equity, the exhibits will be the operating agreement and then joinder. What a joinder is it's a one-page document that the investor signs that essentially says, I agree to be a member of this LLC and I've read and understand the operating agreement. The alternative is if you're doing a convertible note, we include a form of the convertible note as an exhibit to the subscription package. There's a set of risk factors, which essentially says to the investor, you know and acknowledge that you will most likely lose all of your money, and you're okay with it. There's an investor questionnaire, and the investor questionnaire leads us to the definition of accredited investor. So the way that this investor questionnaire works is that the investor fills out a form, answers a number of questions. Your lawyer should then review it to make sure that the investor has checked the boxes that indicate that they're an accredited investor. Here's what that means. It's an individual that has an annual income and net worth of $200,000, or with a spouse has an annual income and net worth of $300,000 in each of the most recent 2 years, with the expectation of reaching the same income level in the current year. And then either individually or jointly with a spouse has a net worth of $1 million, excluding the positive equity in such person's primary residence. I always have to read it because I get it. I can get them turned around. So your investor questionnaire, and then rather than you sending me your business plan projections and sources and uses and me going through that process to regurgitate them into a private placement memorandum, I have you send me your documents. I read them, I comment, I add caveats, but we attach them directly to the subscription package. So you are making those material disclosures that we talked about earlier. You all are probably very familiar with what goes into a business plan, and if you're not, you will be by the end of this Square One cohort. Your projections are what your financial projections look like for the company. And your sources and uses are how are you going to take the funds that are being invested and use them within your company. Okay. So that really is the end of the subscription documents section. I'm going to talk about traditional loans in this phase 2 of raising capital, but I want to just take a pause and ask if anybody has any questions on subscription. Yes, go ahead.
A question about the business side.
Yeah.
With the disclosure, so on it, when you go to the SEC, and obviously public companies are traded, you get all the information there, but then I run into confusion on knowing certain, the small, private, or whatever size, but a private company, I can't decipher why some of them disclose certain information, even up into like what they're going to make and the different series. You can have another company that's similar going through the same series of funding, and they don't disclose anything, but they disclose a little bit. Where can I go to find why those two similar companies, some disclose versus others?
Yeah. Well, there's a good reason. So for publicly traded companies, the disclosure requirements are much higher. They have to file annual reports and quarterly reports, and it's a much greater disclosure. The privately held companies, for certain raises, have to file what's called a Form D, which is some very basic disclosure information about the capital raise. But in certain situations, with smaller raises, you don't even have to file a Form D. So for your typical privately held company, other than the Form D that's been filed with the SEC, if any, there's no requirement for disclosure or for public filings.
What about like the state can set a higher bar? That's why, is that why some companies that are here in Missouri that are private, they have like just almost as much information as public? I still can't figure out why they would do that.
Let me ask a question. When you say information that's public, what do you mean?
You can just go to the SEC website and you can pull up a private company and you see disclosure there that it's like, well, why are they disclosing this if they don't have to? And I was wondering if it's because the state set different standards.
So each state has a set of blue sky laws, and those blue sky laws are the state-specific securities laws, but they don't typically have a higher, they may have different standards, but not typically higher standards that require a federal filing, right? I think that's where the disconnect is. The state wouldn't really dictate a different federal filing. But, I think that's probably it. It's also, what else it may be is that a privately held company that does a certain kind of capital raise that doesn't fall into those exemptions that we talked about has to register the securities that it's issuing with the SEC. So you may be finding companies that didn't fit into an exemption for whatever reason and have had to do the full filing with the SEC. I bet that may be it. Somebody else have a question over here? Nope, over here? Yeah.
For the capital raising, you're talking about investment, and also there's other type of, you can raise, say, for partnership, all these kind of different. So you have to use the same subscription document for those different types.
Yeah, so are you talking about raising money in a partnership versus an LLC versus a C Corp?
Partnership or investment, you say a Series A, B.
Oh, yeah. All of that, absolutely. Now, you get to, more investors, higher dollars. That dictates a private placement memorandum in a lot of situations. But Generally, yes. I mean, we've done a Series A that was $500,000 to, I think, 7 or 8 investors that were all accredited, and we use this subscription package. Absolutely.
So that's the investment.
Yeah.
The partnership will be different. Say we provide this service for
Yeah.
the big company, maybe the big company give some money,
Yeah.
funding the capital for that purpose. You can own some rights of that.
Yeah.
So how that be different
Well,
from
so
the investment?
I've actually never had a partnership that raised capital as like through a startup process. Have any of you guys?
No, but I think, are you talking about actually having a partnership with that the vehicle for investment essentially is that you're doing a partnership agreement, and that part of that is an equity, there's an equity component to it?
Right.
So I think he's, rather than this, I don't think he's referring to the partnership raising money.
Got it. Sorry for the confusion. Okay. So you're talking about forming a partnership that's then going to be the entity that invests in a company?
Yeah, I saw this, say, a small business, they have a unique technology, they can partner with the big business. The big business will, say, have kind of partnership, research development or something.
So kind of like a joint development agreement?
Right.
Yeah. I mean, we see that a lot as well, where you have 2 companies working together to develop a product. Sure. I'm still a little lost on how that plays into raising money, though.
You're using a subscription agreement for that.
No, that's more of a partnership, not a partnership agreement, but a joint development agreement. We've done something like that. Or, gosh, Sarah, what did we just do? It was a joint development agreement. Yeah, okay. Yeah, thanks. Sorry for the confusion. Yeah?
Can you talk a little bit more about the high-level mechanics around a convertible note? Because I think there's a lot of value in understanding the difference between an investment that's just kind of a straight line investment and a convertible note.
Yeah.
And that's something I didn't understand until I got to that point. So there's
Sure.
a lot of value knowing that's a tool at this stage.
Yeah, well, the hard thing about a convertible note for some folks is that a convertible note is really seen as bridge financing. It's either something that's used very early stage because there's really no value to the company, or it's a bridge in between rounds. And people really tout convertible notes as a great tool because, again, you don't have to set a value of the company, right? But the problem is that, and again, to your point, the pieces that go into a convertible note are, what's the interest rate going to be? What's the term of the note? So when is the maturity date? And then what's the discount upon conversion? And then what circumstances lead to conversion? But the problem that startups run into, or founders run into, is that if you get to the maturity date and that's all you have in your convertible note, and you haven't had one of those events that allows for conversion, you're required to pay the money back. Right? It's a loan, it's a loan, right? But that's how the maturity date works. So a lot of times what we advise our clients is to go down the valuation path, right? Put a value in the note. So let's say that it's an 18-month term. So upon maturity, which is that 18-month, put a value in there at which the note converts, right? But now you're playing the valuation game again. Yeah.
So say what it means within a note converts. I don't know if people have an understanding of
Oh, no.
the higher level.
Awesome, thank you.
Maturity versus
Yeah, no.
what it means to convert versus what it means to mature.
Sure, no, that's awesome. So thank you for pointing that out. Sometimes we forget. So, 2 ways that you convert, right? But both the mechanics are still the same. What was a loan, and again, I'm going to put that in quotes because
That's what's converting. You're taking a loan and you're converting it into equity.
it literally rolls into units of ownership in the company. Or units of stock in the company, depending on if it's a C Corp or an S Corp. And it converts at a discount in certain situations, which is typically like a 20% discount. But either which way, it goes from being money loaned to the company into an equity interest in the company. Got it? Yeah. Okay, awesome. Thanks.
If you have co-founders with equal 50-50 equity and they need to capitalize it, one partner can, one partner can't, is a convertible note something that partner with the money could use so they don't have to decide equity at that time until the next financing round?
I don't usually see a convertible note used in those circumstances. A lot of times, you know, if two people are forming a company and one comes to the table with dollars and one comes to the table with know-how, they divide ownership interests between the two according to how much value they put on the know-how and how much value they put on the dollars.
When those dollars run out, what if one partner with more dollars is like, I'll put more, and then what do they do?
You know, it just depends. A lot of times they put more money in at a certain valuation and it dilutes people, it dilutes the other party down. I guess I don't think you couldn't, I mean, I guess you could use a convertible note for that. But a lot of times those founders want more equity right away, right? So they'll put more money in, but only in return for more equity. Otherwise, they go out and try to raise money from more typical investors. Yeah?
And as far as valuation cap,
Yeah.
so it'd be great if people were able to raise money without valuation caps. I've tried it, it doesn't work.
Yeah, I know. I agree. No, thanks for adding that. You know, it's a really hard conversation to have, especially when folks, you know, have heard, well, you don't have to set a valuation with a convertible note. And that's true, but for all the reasons we just talked about.
I guess my question was, how do you determine, or what do you advise your clients as far as what multiple to put for the valuation cap? Because I think that's
huge.
I have not found a good resource on this.
Yeah.
Do you mean the default valuation, or?
So if it converts at the maturity date, what's the valuation?
Well, or what's, yeah.
Or how do you just set a valuation?
What the valuation cap being that if let's say the raise is higher
Yeah.
than what you, than the cap, then you get a better rate for the investor, right?
Yeah.
So everything that's above the cap automatically is being bought as if it was at the cap. You know, that's the way I think about it.
I mean, I wish there was a magic formula.
Yeah.
I don't know any standardized like way of doing how it works.
Yeah.
It's similar to just trying to put a value on a company, right?
Yeah.
Like everyone has a method that they try to use, but there's no like one path that you can follow that just guarantees, you know, that you're going to reach the correct.
Yeah. We see floors and ceilings used sometimes, but when it comes to valuation, I send folks to talk to their accountant because really, you know, a good accountant that practices in the startup area has more experience with this than anybody else. There's no company out there that does valuations for startups, or at least not to my knowledge.
And they make all the sense in the world once your company has revenue.
Right. That's it.
So prior to that,
For sure.
really hard. And that's when convertible notes are frequently used. By the way, to address this issue of the conversion date, there's something else called a SAFE, which stands for Simple Agreement
For
Future Equity.
yeah.
I just sent the link to Christie, so she'll be emailing it out.
Oh, okay. So it's going to be emailed out to people. So the point of a SAFE is that it's an agreement to buy equity in the future, and it does not carry a maturity date. That's what, because it's not actually equity. It's carried on the financial statements of the company as equity, but excuse me, it's not a loan. It is a form of equity that's paid in the future. So it's very new. So it's only been used on the West Coast for about 2 years now. It was innovated by the Y Combinator. So I don't know if any of you know that certain startup organization. So we may be hearing more about it here in St. Louis because there is this advantage of avoiding the maturity date and therefore the false urgency around needing to have a default valuation exercise at a certain point in the future. But anyway, I don't believe there have been any done in St. Louis. As of a few months back, I checked with the accountants that as far as I know are the most frequently used. And when asked about it, they said, a what? So,
There have been.
looked into it.
Yeah, there have been a few done in Missouri. MTC's seen one of them. Here's the thing, a SAFE, a KISS, 500 startups, they all have these really great documents that are simple and don't require a lot of negotiation, but they're only, right, but they're only drafted for corporations. And to convert them into use for an LLC, my understanding, and I haven't done any of the ones that have been done here in town, but my understanding from California Council that does these pretty regularly is that it's incredibly expensive and time consuming. So I'm getting
We're running into our wiggle room.
Yes,
So if
okay.
we can wrap up in the next
I can.
5 to 7 minutes,
Absolutely. All right, great. So I'm just going to put a slide up here on traditional loans. The upshot is that unless you are a startup that has a founder with a really high net worth, this isn't going to be in your toolbox, but still worth having a conversation about. And these are the critical documents that go into it. A loan agreement, a promissory note, and then some sort of security. Angie touched on personal guarantee. There are others. She also touched on a deed of trust. Let's talk about phase 3, which is general contracting. We talked about confidentiality agreements already. In an employment agreement and an independent contractor agreement, you'll often see confidentiality language incorporated into the body of the agreement. In master services agreements, I highly recommend that you do a separate confidentiality agreement, and here's why. When one company starts talking to another company about doing business, they often exchange confidential information that's outside of a service relationship or another contracting relationship. So if you do one confidentiality agreement that acts as an umbrella over the relationship, it protects everything that's disclosed between the two parties, even if it's outside a specific contract. So we talked about employment agreements. Missouri is an at-will state. It means you can hire and fire at will. That said, important things to have in your employment agreement, important reasons to have an employment agreement and to put these things in it. Non-compete, which Angie talked about, non-solicitation, the 2 flavors of which Angie talked about, not soliciting employees and not soliciting existing customers or clients, and then invention assignment. And what that says is that if you have an employee who is doing work for you, while they're doing work for you, they invent something, they assign that invention to you. So everything that they develop while they're your employee goes to you. It's really important when intellectual property or you have a lot of trade secrets involved in your business. An independent contractor agreement is often used. The Missouri Supreme Court has a 20-factor test to determine if you are an independent contractor. It's a facts and circumstances test. You don't have to have all 20. It's available online if you want to see it. But material things are control, right? Can the independent contractor say no to an assignment? Does the independent contractor have their own tools? To that end, we don't typically see non-competes in independent contractor agreements, but we do see non-solicitation and invention assignment, as well as insurance provisions for the contractor since they're often not covered under the employer's insurance. And then we see most often a master services agreement used as a method for contracting between 2 companies. The way that a master services agreement works is that it says, I company or you vendor are going to provide certain services to me company, and here's the rules by which you're going to perform. Typically how they're set up is that the boilerplate language is in the body of the agreement. All the deal-specific terms are in the schedule of work, and if they're drafted right, it means that without amending the agreement, you can append new schedules of work to the master services agreement so you don't have to go back to your attorney. It has insurance protections, and then real quick, on the license to use the intellectual property, here's how this works. It says, I have intellectual property that I am going to use to put together a deliverable to you. When I give you that deliverable, you own the deliverable, but let's be real clear, I still own the intellectual property. But I get that in order to use your deliverable appropriately, you need to use my IP, so I'm going to give you a license to use my intellectual property. It's going to be a non-assignable license, it's going to be non-exclusive, and I'm going to require you to only use it within your company and nowhere else. But that's how you get around it. And a lot of people struggle with that concept. I wish I had more time to talk about it, but maybe Brian will touch on it in his presentation. And then finally, exit. This is phase 4, M&A, right? Typically 2 types of transactions, an asset purchase or a stock purchase or a membership interest purchase. Again, you see confidentiality agreement up there. That should always be step 1 in that process. With an asset purchase agreement, you typically create a separate company that purchases the assets of an existing company. There's no real successor liability unless it's specifically assumed in the asset purchase agreement. What that means is that I buy the assets free and clear unless I agree to assume specific liabilities. And that's different than in a stock deal. In a stock deal, I step into the shoes of the existing shareholder, and as such, if the company has litigation or loans or what have you, I step into all of those problems of the existing company. With an asset deal, you get more of a clean slate. With an asset purchase agreement, all of the contracts of the existing company that you're buying the assets of have to be assigned. And with a stock deal, they don't, because the company continues to exist. All right, so here's what we've talked about today. We've talked about formation, we've talked about how to raise money, and we've done it through a capital raise or a traditional loan. We've touched on the critical documents involved in general contracting, and then the 2 general critical documents involved in M&A. And I know we don't have much time left, but does anybody have any questions that I can answer quickly? Nope, nope. All right. Thank you guys so much. Appreciate it.